banking, Freemasonry, the Judiciary Act, the Crimes Act, Criminal Code Act. We're going to cover most of these. And we're going to cover them gently, compassionately and quietly. Act of Settlement. Now I'm saying this because that's the cornerstone of the English Parliament. An Act of Parliament UK that resolved the question of royal succession unsettled after the Glorious Revolution of 1688. The question was resolved by limiting the Crown to members of the House of Hanover who were Protestant. Big stoush over that one because the Vatican doesn't like that. There's a lot of people who don't like that. The Act also provided that the sovereign must be a member of the Church of England, see, because those words appear in these legal documents. That's why I use those references. And it established that judges would hold office during good behaviour. Oh, that's cute. That's cute. That's why they don't like the Act of Settlement. Rather than at the will of the sovereign. Since the Australia Act, the High Court has stated that the sovereign is the elector. Next one, mate. That's the four great charters of England that we're going to touch on. The four great charters, which, because England doesn't have a written constitution, so it works off these. Magna Carta 1215, the Petition of Rights 1628. I'll just stop there. That's an interesting little scenario. Coke, who was the Attorney General of England, said to the King at the time, Magna Carta's above you. King didn't like that, so he chucked him in the Tower of London for 2 years and sealed his house. In 1628, Coke was out and they had the Petition of Rights and he went on to be the Attorney General and the most famous judge in England. Habeas Corpus Act, now that's when you can do a writ of habeas corpus and they have to bring the person to the court within 2 hours of the writ. The Bill of Rights, 1689, the most historical bill we have, and the history of that is really important. Next one, mate. Bill of Rights, 1688, one of the four great charters of English liberty embodying in statutory form all principles of the other three charters, namely Magna Carta, Petition of Rights and Habeas Corpus. Each act embodied the other one, kept bringing it in. When you take the Crown out, you cut all this off. You've cut off a lot of your liberties. Remember what I said, if you sleep on your rights, you'll lose them. Magna Carta, the Great Charter. It's called the Great Charter because it's literally the one that introduced trial by jury. The English Charter that King John granted to the barons in 1215 and that Henry III and Edward I later confirmed. There's been a hell of a stoush over Magna Carta in the history of Magna Carta. It is generally regarded as one of the great common law documents and as the foundation of constitutional liberties. America was founded on this. Petition of Rights 1628, one of the four great charters of English liberty, establishing that no man be compelled to make or yield in gift, loan, benevolence, tax or such like charge without common consent by acts of Parliament. Habeas Corpus Act, one of the four great charters of English liberty, securing to English subjects speedy relief from all unlawful imprisonments. The Habeas Corpus Act does not apply in Scotland, enacted in the United States as a constitutional guarantee of personal liberty. When you cut the Crown, you're cutting a lot of acts. Act of Supremacy, a statute that named the English sovereign as supreme head of the Church of England. The Act was passed in 1534 during Henry VIII's reign and confirmed in 1559 to counteract pro-Catholic legislation enacted during the reign of Mary Tudor. That's your history. That's your background. They're really important acts in there for liberty and freedom and justice. What they did when they took the Crown out is cut a lot of this. They just nullified it. Because you can't just have a continuum, you have to go on and create different acts. Act of Parliament of Scotland. A law passed by the Parliament of Scotland between its creation about the 17th century and 1702. A law passed from 1900 onwards by the new Parliament of Scotland created by the Scottish Act of 1998. Act of Union. Any of several acts of Parliament uniting various parts of Great Britain, the term applies to the laws in Wales Act 1535, which united with England and made that principality subject to English law. The Union with Ireland Act 1800, which abolished the Irish Parliament and incorporated Ireland into the United Kingdom of Great Britain and Ireland. It is also but mistakenly used in referral to the Union with Scotland in 1707, which was not made by statute but by treaty. Approved by separate acts of Parliament of Scotland and England, which by treaty dissolved themselves and created a new state of Great Britain with one Parliament, the Parliament of Great Britain. Now it's that Parliament that owns your Commonwealth Constitution. They are the legal owners of it. You can't just toss the Crown out and let you know what you're doing here. Two principal doctrines here. One is separation of church and state. Now what's happened with the church in Western Australia when the Crown went, or the church in the Commonwealth, is that the church should have always been above the jurisdiction of the state. But once it incorporated, it come into the state. And then once the state went belly up and changed its jurisprudence, the church followed it into that non-legal entity condition. And then you have the separation of powers. Now I'm going to read something that we took from a Supreme Court document, and I'll read it, but it's actually a pack of lies. Separation of powers. Now this comes from the Supreme Court booklet that you can pick up at the desk of the Supreme Court. It says the judiciary is one of the three arms of government along with the Parliament and the executive. The judiciary is independent of the other two arms of government. After January 1, 2004, that doesn't apply. This independence is one of the most vital safeguards of a democracy. Well, hello. What did they do putting the Supreme Court Act into the Acts Amendment, Repeal Courts and Legal Practice Act that took the Crown out? That destroyed separation of powers. And they cannot be independent because they're the offender. And that's what it says. This independence is one of the most vital safeguards of a democracy. Judges are bound by their oath and affirmation to do right to all manner of people according to the laws and usages of the state without fear or favour, affection or ill will. Security of tenure is an important part of judicial independence so that governments cannot influence the decision of a judge. That's rubbish. We know they control that decision. A judge is appointed until the age of 70 or until he goes to jail, and cannot be removed from office except by the governor, and that's rubbish, because Section 34 of the Crimes Act 1914 states a judge or magistrate exercising federal jurisdiction with a personal interest, 3 years jail. They didn't put that in there. Except by the governor following an address from both houses of Parliament. Where did they get that from? The Act of Settlement, 1700. So don't think they're old acts. They're running your government, those acts. They just don't like them because they've been told in Europe, get rid of them. They can't repeal them in the UK Parliament. They're unrepealable. They were put together by the best lawyers in England at the time. So they're just going to abolish them by ignoring them. Remember what the magistrate said? If you sleep on your rights, you lose them. Parliament's function is to enact laws. The courts are bound by statutes, law made by Parliament by decisions made by previous cases, precedent. Now that's what they're doing. They're trying to get precedent cases in after January 1, 2004 and said, oh, the court ruled. The problem is, was the court sitting legally to make the ruling? That's the issue. And that's got to go to a jury, not to them. The courts also pronounce law in those areas where Parliament has not legislated. Oh, isn't that cute? Isn't that cute? The power of the court to pronounce law is called upon only where the authority of a statute or previous case law is lacking. What they're really saying is when you don't wake up what we're doing. Under the Constitution, Parliament is supreme. Hello, we've got a shock for them. The elector is. Parliament can change the law in any way it chooses. This is from their own document. From their own document. And when they knew we were in town, they ran a little article the other month that says, governing our state. It's your West Australian paper. And it tells how the state's governed. What it leaves out on this is that at Section 73, there's a portion that's got to go back to the elector. Left out. Anyone wants to notify the person who wrote the article, feel free. The executive is constituted by the governor. Now listen to this.